All right, we're back. My first live stream in a while. Hello, everyone. It's Leonard French, your favorite copyright attorney, back with a YouTube public live stream for the first time in a few months. And what a topic. The Satanic Temple has won their preliminary injunction motion against Saucon Valley School District. And if you know about preliminary injunctions from my channel or from something else, preliminary injunctions have a standard. You have to have a likelihood of success on the merits. So when someone can get a preliminary injunction, it doesn't mean they won the case, but it means they're likely to win the case because the judge wouldn't grant the preliminary injunction without it. Next, thank you to my sponsors. Lawful Masses is a community-sponsored channel. I don't advertise for VPNs or shoes or wallets or tank games. My sponsors are Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, Gutbrodj, TechTechPotato, King Aries, and Kyle Siefring at the $50 level there this month. Thank you very much for your support, everyone. All right, so today's update is an update. We're only going to go over the update. There's a couple hours of material in previous videos and documents and things like that. So please go look at the previous video if you have a detail here or something that I skimmed over. But I'm going to try to give you a short recap. This is a public access situation. This is a public forum, a true public forum situation. A government entity, a school district, a public school, has opened its facilities for after-school programs not sponsored by the district. Outsiders can rent a room, basically, and the idea here is that if you're going to allow some community members to rent rooms, you have to allow all community members that want to rent rooms to rent rooms. There's some practical limitations there, but those don't apply in this situation. This is just one club that applied and was initially approved, and then there was outrage because the club is the Satanic Temple After School Satan Club in a historically Christian town area, religious area, and it was not received well. The community, parts of the community were outraged. You're going to see some of that today. The judge includes that in his opinion. And the outrage also included a threat from an out-of-stater who left a threat of a shooting on the school's voicemail and closed the school for a day and a half. And then the school used all of that outrage and the threat as a pretext, as a reason to deny the Satanic Temple and the After School Satan Club instead of upholding the law and the Constitution and governing as the public school should govern itself. So let's go over all of that. We'll start with the judge's introduction to his opinion, Judge Gallagher in the Eastern District of Pennsylvania. And we're going to skip a little bit because the good stuff is in a couple sections and is long enough, and I don't need to subject you to anything more than that. So, everybody, strap in. No problems. Okay, good. No sync problems, no lighting problems, no sound problems. We're good. Let's jump in. This is the overview. Judges write different sections. This is Judge Gallagher's overview. When confronted with a challenge to free speech, the government's first instinct must be to forward expression rather than quash it, particularly when the content is controversial or inconvenient. Even when faced with speech we deem offensive, the solution is more speech, not less. Nothing less is consistent with the expressed purpose of American government to secure the core, innate rights of its people. Here, although the Satanic Temple's objectors may challenge the sanctity of this controversially named organization, the sanctity of the First Amendment's protections must prevail. Indeed, it is the First Amendment that enumerates our freedoms to practice religion and express our viewpoints on religion and all the topics we consider sacred. Though the First Amendment is often inconvenient, depending upon one's perspective or responsibilities, this inconvenience does not absolve the government of its obligation to tolerate speech. Even in the school setting, a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint is not enough to justify the suppression of speech. And note the quotations here, or the citations, I mean. The judge is citing to Child Evangelism Fellowship of New Jersey, a case involving the Good News Club, who's also involved here. They're not a party. The school rather preferred the Good News Club over the After School Satan Club, go figure. And the Good News Club was allowed and even given sort of waiver of some of the requirements of the rules that were instead applied to the After School Satan Club when they were denied. You'll see. At this stage of litigation, because the record before the court indicates the decision of defendant Saucon Valley School District to rescind approval of the After School Satan Club's use of district facilities was based on the temple's controversial views on religion and the community's negative reactions thereto, the court grants in part and denies in part the motion for preliminary injunctive relief. The district must permit the ASSC to meet at the location and on the dates upon which the parties previously agreed during the current school year. The district is not required, however, to distribute permission slips to students. We'll go over that as well. So we're going to skip ahead a little bit. The ASSC had been approved, which is sort of a key fact here. It doesn't really change anything. They would still have to be approved eventually, just sort of the angle or vector through which we're doing all of this. They started by being approved, and then on February 20th, the district superintendent began receiving phone calls and emails from district parents and community members expressing concern about the district sponsorship of the TST's club. In response to these concerns, the district superintendent issued a letter via email to the entire district community explaining the district had approved the club for use of school facilities after hours, and the club was not a district-approved club. The text of this email was posted on the Facebook page, though that post has been deleted, and in pertinent part that read, "It is very important to note that the district does not endorse any of the groups or content affiliated with the groups that host after-school events on district property. It is also important to note that the ASSC is not a district-approved club." They're trying to disclaim that they're not sponsoring the ASSC. This is the reason. They're using this as the reasoning that the ASSC is not allowed to meet, because there was confusion over whether the ASSC was sponsored by the Satanic Temple or sponsored by the school district. The judge starts to cite to events, to emails and messages that were left or sent to the school. An anonymous person left a voicemail about kids that have fun, and he was going to come and shoot everybody because of the After School Satan Club. After receiving the threat, Vlasaty closed the school, and she closed the school for that evening, and she closed the school the next day. During this same time, the district and superintendent received over 40 phone calls and 50 emails or handwritten letters daily from concerned staff, parents, and community members. Indeed, defendants' exhibits include numerous email exchanges between the district superintendent and community members and parents, including the following. And the judge is going to give us 2 pages of all of these complaints so you can see what the community was sending to the school. At what point do we prioritize the safety and education of our students over a club that is allowed to meet after school? Having to cancel school impacts every family in the district. I understand the school cannot discriminate over the groups that use the building, but if it impacts the safety and security of the school, action must be taken. Another, I wanted to email you regarding the After School Satan Club, or rather Satan After School Club, that has been approved by the district. While I know they are protected by the First Amendment, I am petitioning to remove all religious clubs after-school groups. Let the decision be left outside of schools for the parents to introduce what they feel is appropriate to their children when they feel it is appropriate. Another, I wanted to take a moment to contact you regarding the After-School Satan Club that you are promoting inside your school. To my knowledge, schools are not permitted to host nor promote religion. Certainly, hosting satanic activities is promoting a religion. Clearly a commenter who didn't know there was already a Good News Club established at the school for 7 years. Another email. As a proponent of public secular education, I support this decision. Equality in public spaces, what's fair is fair, or better yet, no religiously affiliated organizations should be allowed within publicly funded districts whatsoever. Another, you are as weak as lame duck President Biden. You should be ashamed for bowing to woke policy instead of standing up for what's right. A message that doesn't seem to understand what a lame duck president is. Another email. I appreciate the heads up regarding this new club/organization. My concern lies with the hours this would occur. I would be horrified if there would be a chance of them running into my children, as I am of the belief that these types of organizations intentionally choose schools as a potential way to access children. Again, the Good News Club in the school for 7 years. Permission slips being sent home by the teachers. Another one, as the superintendent, you need to fight back for this school. Saying yes just because the school isn't allowed to discriminate isn't allowed to discriminate against such clubs is not a good excuse for me. I can sure think of 100 or more people that would back you and fight with you to get this out of Saucon Valley immediately. Another, please shut down all religious after-school clubs if that's what needs to be done to keep Satan out of the building. Change the policy or fight the law. Another, how exactly does this provide a safe environment for our children? What's next? The after-school heroin club? Is the school going to put up a fight on that one or just let it go through because of discrimination? Who is running this organization and club? The Satanic Temple and Reason Alliance. It was very clear. And what is their contact information? I think it's the satanictemple.org, .com. Just Google it. All I needed to do was look at the disgusting books in your elementary school library to dissuade me from sending my children there. Approving a Satan club simply makes it official. You can go on and on about the Supreme Court, but I again say to you that yours is the first school district in all of Pennsylvania that accepted this club. Others said no and welcomed the lawsuit. They are at least attempting to do what is right. I think it was the first in Pennsylvania. I don't think there was another lawsuit. Although the decision, says another, to have the ASSC is one I personally disagree with, I understand the importance and legalities of being fair, equitable, and tolerant of all beliefs, and allowing equal access to school district facilities is what you are asked to do. Another, I'm writing as a concerned parent, I'm actually a bit in awe that this campus is giving in to this type of ridiculous, one-sided religious behavior. I myself am not a religious person, but the work of evil, I would hope, would be avoided in any place where children are meant to be kept safe from that very thing, evil. Maybe such clubs should be held at a community center in a neutral, or natural, it says, natural environment. The natural environment of your local community center. There certainly is a natural air about it, isn't it? Since our school is non-religious. All right. While I understand the First Amendment, freedom of religion/assembly, I am puzzled at the school allowing for a group that claims religious affiliation with Satan, not because they believe in Satan, okay, so they do get that, or religion for that matter, but they use the term to be provocative. I don't know about just provocative. Given these highly charged times, wouldn't it have been wiser to revoke all religious groups' charters, etc.? During this time, the district became aware of 2 posts on social media which were not affiliated with the Satanic Temple, but the school treated them as if they were affiliated with the Satanic Temple, and then found errors in them that they didn't have this advertising disclaimer, and they said, oh, the Satanic Temple did not include their advertising disclaimer on these posts that these third parties made. The judge is going to get into that. We can skip ahead. Read the highlight page 11. Based on these 2 Facebook posts, the district concluded that TST violated the advertising restriction under Policy 707, and on February 24th, the district rescinded its approval for TST to use district facilities. TST then sued, March 30th, 2023. Their complaint alleges the district's decision under Policy 707 to rescind approval from and prohibit the ASSC from using school facilities is unconstitutionally based on the viewpoint and or content of plaintiff's speech, including plaintiff's particular religious viewpoint. TST alleges the district's decision is based on an unconstitutional heckler's veto arising from community members and others' disagreement with and hostility toward the viewpoint or content of plaintiff's speech, as well as animus towards plaintiff's religion. TST brings claims for violation of the First Amendment's free speech, establishment, and free exercise clauses, as well as for violation of the Pennsylvania Constitution. The complaint seeks declaratory, injunctive, and monetary relief. The next day, they filed a motion for a temporary restraining order. They asked the district must permit ASSC to meet. They must reschedule the missed meetings. They must distribute permission slips like the Good News Club got, and they must not impose other unconstitutional conditions or retaliate. There was a hearing on this motion for a temporary restraining order, and there was an agreement on April 6th that the ASSC could meet May 10th, May 17th, and May 31st. I think those are the new dates. And then the school still opposed the temporary restraining order, saying, hey, we revised our policy, we agreed on dates, we're going to fix it. You know, you don't need the temporary restraining order. But of course, that doesn't change much. All that stuff had already happened. So now the judge makes a decision. How you doing so far? You need a break? Am I still coming through? All right. We're going to get into the legal standard here. I'm going to skim a little bit on injunctions, but then we're going to get into the meat and potatoes of it, and you'll be rewarded for your patience. Your 17 minutes of patience so far. A motion for a preliminary injunction may seek prohibitory or mandatory relief. What we're trying to do is maintain the status quo. The status quo is the last peaceable, non-contested status between the parties. So think about that in this case. What happened in this case? You had the application of the ASSC. It was approved. Then there was this big controversy. Then the application was rescinded. So the last peaceable, non-contested status between the parties is the ASSC was approved and was about to meet at the beginning of March. So, the relationship that last existed between the parties was the approval of the use of school facilities. And the judge also then goes over the other standards for a preliminary injunction. We're looking for a probability of success on the merits and irreparable injury. There's also some considerations for the public interest and harm to the opposing party. We're not going to worry about that too much here. The judge will go over that as well. In the First Amendment, or with First Amendment cases, the likelihood of success is there's a burden shifting problem here. The burden shifts to the government because the First Amendment is quite an important freedom or right. So once the plaintiff has established a basic or prima facie case, then the government has to explain why in the world would they burden your freedom of speech. So now here is the judge's analysis section, and here's the meat and potatoes that I think you're going to really enjoy. Because plaintiff's motion is premised on alleged First Amendment violations, the district has the burden of justifying its restriction on speech. If TST is able to state a colorable claim that the district's action restricts some form of speech, the burden shifts to the district to justify its restriction under whatever level of constitutional scrutiny is appropriate, intermediate, or strict, given the restriction in question. If the government succeeds in showing constitutionality, then the preliminary injunction fails. If the government cannot establish that this regulation or law or ruling is constitutional, then the challenger must still demonstrate irreparable harm, though that's pretty easy to do when you're moving for a temporary restraining order on a freedom of speech right. The court notes at the outset that a school district is under no obligation to open its facilities to expressive activity by outsiders. A public school district, just like a private property owner, has the power to preserve the property under its control for the use to which it is lawfully dedicated. So the school can open its doors to outsiders or not. But once you open it to outsiders, it's all outsiders or no outsiders. However, where here, as a public school, decides to open up facilities, such as classrooms or meeting spaces for use by the general public, it creates a designated or limited public forum. And we're not actually going to be that concerned about whether it's a designated or a limited public forum, because the sort of equality of access rules apply to everyone in both situations. Regardless of whether a school district created either, the district is not permitted to discriminate against speech on the basis of viewpoint, citing to Good News Club versus Milford Central Schools. Remember, it was the Good News Club that was allowed into Saucon Valley when the ASSC was not. Thus, if the district discriminated against TST's speech on the basis of viewpoint, whether the district created a designated or limited public forum is immaterial. Here, TST states a colorable claim that the district's decision to rescind approval of its application and prohibit it from using school facilities for the remainder of the current school year restricts TST's speech and is based on their viewpoint, which shifts the burden to the district to justify. TST credibly alleges the district rescinded approval of their application because of TST's controversial viewpoint and the objector's reaction to that viewpoint. TST's application for the use of school facilities was approved February 16th. Then the superintendent began receiving phone calls and emails from district parents and community members expressing concern, February 20th. Then, 21st, the district received an anonymous shooting threat. Between the 20th and the 24th, the superintendent received numerous complaints about the approval of TST's application and, of course, the threat. On the 24th, the district rescinded approval for TST to rent district facilities, 8 days after initially approving their application, and only 4 days after beginning to receive complaints. The district's public statement announcing its decision to rescind approval, as well as the disruption and chaos experienced by the district and the community, the district subsequently refused to permit TST from reapplying to use school facilities for the remainder of the school year. Based on the district's quick rescinding of TST's application following widespread community backlash and threats of violence, plaintiff colorably alleges the district engaged in viewpoint discrimination by rescinding its approval. This conduct is unconstitutional, as the censorship of messages because they are controversial is viewpoint discrimination. And then there's a bunch of sites. Northeast PA Free Thought Society versus City of Lackawanna, Monroe versus Central Bucks School District. These are all Pennsylvania cases. The First Amendment generally does not permit the heckler's veto, allowing the public, with the government's help, to shout down unpopular ideas that stir anger. Therefore, under the burden-shifting framework for analyzing a motion for preliminary injunction in First Amendment cases, the burden now shifts to the district to justify its restriction on speech under whatever level of scrutiny is appropriate. The district fails to meet its burden. The district argues its restriction of TST speech is justified under the First Amendment because the district determined TST violated the district's content-neutral advertising restriction contained in Policy 707 by posting social media advertisements on February 20th and 23rd that failed to clearly communicate the ASSC was not sponsored by the district. The advertising restriction requires all organizations not sponsored by the district to clearly communicate that. The district asserted in its briefing and at oral argument that these violations of the advertising restriction contributed to confusion and outrage in the local community due to the mistaken belief that the district was sponsoring the ASSC. The district further suggests the confusion about district sponsorship caused by TST's advertising restriction violations may have contributed to the shooting threat. Quote, the district later learned the suspect who allegedly made the threat against the district had learned of the connection between the club and the district on Facebook, thereby demonstrating the importance of the advertising restriction in Policy 707. If only they followed the important advertising restriction in Policy 707, this man would not have threatened to shoot up the school. It's the Satanic Temple's fault that this man threatened to shoot up the school. The first social media post was a Facebook post made by a user identified as Nikki Romy. The district contends this post violated the advertising restrictions because the post was directed to Saucon parents, district parents, and stated that Pennsylvania's very first after-school Satan Club was launching at Saucon, and that participants did not have to be students at Saucon Elementary. This, according to the district, strongly indicated that the club was being sponsored by the district in contravention of the advertising restriction in Policy 707. It's simple, guys. Look, somebody posted on Facebook. We have no idea who they are, and that's attributed to the Satanic Temple. Second, the district argues the Facebook post attached an image of a promotional flyer that differed from the flyer TST had produced in discussions. The flyer attached to the Facebook post identified Saucon Valley Middle School in large font in the center of the flyer, which, according to the district, indicated the club was being sponsored by the district. And it looks like this. So there you can see very clearly in the middle it says Saucon Valley Middle School and the address of the school. And then down here at the bottom in tiny letters, I've highlighted it. It wasn't originally highlighted. It says this is not an activity of the school or school district. However, it does up here say, it's here someplace. It says this is sponsored by Satanic Temple and Reason Alliance somewhere on here. There's too many letters. I can't see it right now, so we're going back to this. The district also argues that this post by Nikki Romy was ratified by TST because they loved the post. TST's account loved Nikki Romy's post. The second was a post on TST's national Facebook page. It said, the After-School Satan Club is coming to Hellertown. Saucon Valley Middle School will host the first ASSC, open to both elementary and middle schoolers. Although the post included a link to an online permission slip, the post attached a picture of a flyer completely unlike the sample flyer. The flyer attached to this Facebook post did not include a disclaimer. However, the flyer did state the club was sponsored by TST and indicated the club was held at Saucon Valley Middle School. In its briefing, the district contended this post also violates the advertising restriction because using such language as Saucon Valley Middle School will host the first ASSC strongly suggests district sponsorship of the ASSC. The district contends its decision to rescind approval of the application resulted from these two violations of the advertising restriction and the ensuing disruption that violation caused to the district's educational programming. The district rejects TST's viewpoint and content-based discrimination arguments that rest on the supposition that the district only took the action it did because of opposition to some in the community to TST, that the district acted in response to a proverbial heckler's veto, arguing the evidence shows the district continued to make plans for TST's use of district facilities even in the face of an avalanche of opposition to the club from the community, and even after receiving the shooting threat, and that it was not until the district learned of the violations of the advertising policy that it rescinded approval to use district facilities. If this all sounds like total bullshit, just wait, the judge roasts them. In response, plaintiff contends the district's advertising restriction violation justification is pretext. The court agrees. Use of government regulations or statutes as pretext to shut down an organization or business because of the content of its speech or some undesired secondary effects of that speech violates the First Amendment. The judge cites to Akara v. Cloud Books, also Abu Jamal v. Price. I don't know why this quote is in here twice. Plaintiff entitled to a preliminary injunction preventing Pennsylvania Department of Prisons from enforcing a rule prohibiting inmates from carrying on a business or profession as a pretext to violate plaintiff's First Amendment rights. The district has the burden of demonstrating its decision to rescind approval of TST's application is constitutional. The record before the court does not support a finding. As the district, such a finding as the district claims that the decision, if I can stop stumbling over my words, the decision to rescind approval of TST's application resulted from a violation of Policy 707, Rather, such a decision was unconstitutionally based on TST's controversial viewpoint. The court makes this finding based on the following 4 considerations. Listen up. The record, 1, casts doubt on whether TST even actually violated Policy 707. 2, the record suggests the district enforced Policy 707 against TST in a manner inconsistent with its enforcement of Policy 707 as to other non-sponsored community groups. 3, the record does not support the district's argument that negative public backlash and criticism was caused by a mistaken belief that the district sponsored ASSC. And 4, the record strongly indicates the district's decision to rescind TST's approval was motivated by unconstitutional considerations unrelated to Policy 707. As an initial matter, 1, it is unclear whether TST even violated Policy 707. The court gives deference to the district's own assessment as to whether conduct violates its own policies. That the court may disagree with the district's determination that TST violated Policy 707 does not, by itself, warrant a finding that the district's determination was pretextual. However, because the record indicates TST did not clearly violate Policy 707, it suggests the district's enforcement was pretextual. The district claims TST violated Policy 707 based on the Facebook posts on February 20th and 23rd that we saw above. However, the district provides no evidence or argument suggesting that the author of the February 20th Facebook post is in any way affiliated with TST or the ASSC. In fact, at oral argument, both parties acknowledged the identity and affiliation of this post's author is unknown. Instead, the district alleges TST is nevertheless responsible for the contents of this post, because the campaign director loved the post on Facebook. Even if the court were persuaded, which it is not, by the argument that the social media likes of a TST member using their personal Facebook account amounts to TST itself advertising or promoting activities held at school facilities such that the social media interaction is subject to Policy 707's advertising restriction, it is not even clear that this February 20th Facebook post violates the policy. The district's chief criticism is that the post attaches a flyer which is not like the sample flyer previously shared with the district. Instead, this flyer references the Saucon Valley Middle School in large font. However, as argued by the plaintiff at oral argument, the attached flyer references the Saucon Valley Middle School, wait for it, in order to identify the location of the meeting. Indeed, the only material difference between the sample flyer and the one attached to the Facebook post is that it adds the name, Saucon Valley Middle School, and the school's address. Logically, the location and address of the club meetings would not have been contained in the sample flyer, which was presumably presented to the district before TST obtained approval to use the district facilities and knew where the ASSC meetings would be held. Moreover, the flyer attached to the February 20th Facebook post states the ASSC is sponsored by the Satanic Temple and Reason Alliance, not the district. Although the district argues the attached flyer's disclaimer is too small, the disclaimer appears to be in the same size and font as the sample flyer disclaimer. The district never claims it raised any concerns with TST about the sample flyer or disclaimer. Based on the foregoing, the record does not support a finding that the posts violated 707's advertising restriction, nor that the post is even subject to the restriction. The second post, February 23rd, which was a post by TST's national Facebook page, similarly attaches a flyer referencing the location of the ASSC as the Saucon Valley Middle School. Again, the flyer also states the ASSC is sponsored by the Satanic Temple and Reason Alliance. The flyer does not state the ASSC is sponsored by the district. However, the post does state that Saucon Valley Middle School will host the first ASSC, open to both elementary and middle schoolers. In a vacuum, this statement that the middle school will host the ASSC arguably suggests the district is more involved than simply providing a meeting space to the ASSC. Critically, however, it is unclear whether the district even considered this Facebook post when it decided to rescind approval of TST's application. Though the superintendent testified the district did consider this post, in its February 24th letter to TST rescinding approval, the district stated its decision was based on the February 20th Facebook post alone. The letter makes no mention of or reference to the February 23rd Facebook post from the national Facebook page. At best, whether the February 23rd Facebook post violated Policy 707's advertising restriction and whether this post was even a basis for the district's decision are ambiguous. Second, the record suggests the district enforced Policy 707 against TST in a manner inconsistent with its enforcement of the policy against other groups. TST argues the district has permitted ongoing access to the forum by a number of groups whose advertising materials have included no disclaimer whatsoever. For example, TST argues the Good News Club, a religious community organization not sponsored by the district, advertises with flyers that fail to expressly disclaim sponsorship by the district at all. Here's what that looks like. The Good News Club, Bible lesson, Bible verse, songs and games, sponsored by Saucon Community Church and Child Evangelism Fellowship. And there's nothing in here that says not sponsored by Saucon Valley. Indeed, a Facebook post by the Saucon Community Church advertising the Good News Club attaches a flyer like TST's flyers that references the club's location at Saucon Valley Middle School. It also says Saucon Valley Middle School right there. But unlike TST's flyers, does not contain an express disclaimer of district sponsorship. Yet, contrary to the district's determination that TST's advertisements violated Policy 707's advertising restriction, the district claims the Good News Club's advertisements clearly communicated that the Good News Club was being sponsored by the Saucon Community Church and Child Evangelism Fellowship. The court fails to see this supposed distinction. Both the Good News Club advertisement and the TST advertisements contain explicit language stating the clubs are sponsored by the Satanic Temple and Saucon Community Church, respectively. Both clubs' advertisements state the clubs are at or hosted by or located at Saucon Valley Middle School. Only TST's flyers contain the explicit disclaimer stating this is not an activity of the school or the school district. Yet the district claims it is TST's advertisements, not the Good News Club's, that violate Policy 707's advertisement restriction. This is why you need judges, people. Could you imagine if we just left this to the community to figure this out? They were so unfair in the application of a equal standard that we needed a judge. We needed a federal lawsuit. We needed a federal civil rights freaking lawsuit because the community, the person chosen by the school board being chosen by the community and the school board choosing the superintendent, could not fairly apply the law, could not equally apply the law. Had to get a judge. Moreover, the district fails to identify any clubs other than ASSC that have been refused meeting space for violating the advertising restriction. Accordingly, TST makes a sufficient showing that the district selectively and inconsistently enforced its advertising restriction against TST as compared to other similarly situated speakers. The district's proffered distinctions and rationale for this inconsistent enforcement are unpersuasive and fail to satisfy the district's burden of justification. This inconsistent treatment strongly suggests viewpoint discrimination. The judge cites the Pittsburgh League of Young Voters Education Fund versus the Port Authority, holding evidence that Port Authority approved several non-commercial ads from other organizations but declined approval of plaintiffs' ads on the basis that they are non-commercial, is evidence that the district court could properly consider this viewpoint discrimination. 3. The record does not support the district's argument that a negative public backlash and criticism was caused by the mistaken belief that the ASSC was sponsored by the district. Rather, as the litany of emails from parents and community members to the district superintendent reveal, the negative community backlash and criticism expressed a frustration with the district's decision to permit the ASSC meetings, not with a mistaken belief that the district actually sponsored the ASSC. A vast majority of the email complaints received by the superintendent reflect a community-wide understanding that the district's decision was simply to permit the ASSC's use of facilities, not to sponsor the club, as evidenced by the following excerpts. So remember, these are emails that are being received while the district is making this decision to rescind the approval. And these people are telling the district, I understand that the school cannot discriminate over the groups that use the building. This after-school Satan Club has been approved by the district. I know they are protected by the First Amendment. You should remove all religious clubs. Saying yes just because the school isn't allowed to discriminate. Others said no and welcomed the lawsuit. I am puzzled at the school allowing for a group that claims religious affiliation with Satan. Even if there was any confusion about whether the district sponsored the ASSC, the district made sure to treat ASSC differently by issuing a February 20th statement expressly disclaiming any sponsorship or endorsement, a move the district itself admitted at oral argument it has never previously made with respect to any other after-school club. They just freaked out that the ASSC had been approved and that the community was not happy about it, and they just went ham. The record simply does not support the district's arguments that its actions were motivated by a finding of legitimate widespread community confusion as to whether the district endorsed or sponsored the ASSC. 4. My favorite. Lastly, and perhaps most compellingly, the record contains strong evidence that the district's decision to rescind approval of TST's application was motivated by unconstitutional considerations unrelated to Policy 707. The district's own superintendent, who made the decision to rescind TST's approval, stated in a March 2nd email to the district, to a district parent, saying, "It is difficult at times when the loudest voices are the most damaging in so many ways. This past week has not been the easiest. We couldn't do what other districts have done. Unfortunately, it would have given the Satanic Temple exactly what they wanted, along with more publicity and ammunition, and we may have been in a position to take the club back after thousands in legal fees. We needed to put ourselves in the best position to fight this, and hopefully keep them out. I am not sure if we will see them back again, but I believe we are in a better position than other districts have been. Sometimes true protection isn't noticed or noticeable immediately." This statement strongly suggests the district's decision to rescind approval of TST's application was not made even-handedly to enforce a content-neutral advertising restriction, but to remove TST from the district's facilities due to the controversy surrounding its viewpoint on religion. Although the district argues TST was not permitted the opportunity to revise its advertising policy materials and reapply for this school year because the district was in the process of revising the policy itself, the superintendent's March 2nd email suggests this rationale is pretextual and that the district's enforcement of and changes to Policy 707 are motivated by an intent to keep TST out. Additional statements confirm this intent. On February 20th, an email from the superintendent to a community member states, "Unfortunately, it is true that an organization exists and in our legal research usually follows school districts which have allowed the Good News Club to use facilities, which Saucon has been doing for the last 7 years, long before my tenure." Jamie Vlasaty was February of 2022. "It also appears that it does what it does for shock value, and if there is community support, it remains. From what the organization stated, there was a community member which called them because of the Good News Club. This was something I would never personally support. Even the district's official statements reveal the decision to rescind approval of TST's application was based on its controversial viewpoint. The district's February 22nd statement advised the superintendent was recommending a full review of the Satan Club's use of our facility due to the shooting threat and the disruption it caused. The statement does not suggest this review was motivated by concerns TST violated Policy 707. There is no doubt the district and superintendent were faced with difficult, time-sensitive decisions. However, the court's analysis is guided by the law, not practical decision-making considerations or the court's own personal opinions. The law requires the court to determine whether the district's decision to rescind approval of TST's application was based on the content of TST's religious viewpoint and the reactions to it. The court concludes it was. Because the record does not support the district's argument, its decision to rescind approval of TST's application was based on a content and viewpoint neutral enforcement of Policy 707's restriction. The district has failed to satisfy its burden to justify the restriction on TST's speech. TST demonstrates a likelihood of success on the merits because the First Amendment prohibits the district from denying TST access to district facilities based on community opposition to TST's speech and its religious viewpoint. As the Third Circuit has held, to exclude a group simply because it is controversial or divisive is viewpoint discrimination. A group is controversial or divisive because some take issue with its viewpoint, citing to Child Evangelism Fellowship of New Jersey, a Good News Club case. The district's decision to rescind approval of TST's application based on its controversial viewpoint on religion violates the bedrock First Amendment principle that speech may not be banned on the ground that it expresses ideas that offend. And here's the case. In Good News Club versus Milford Central Schools, a public school district similarly opened district rooms and facilities for after-school public use. There, the local Good News Club sought permission to use the district school cafeteria for weekly after-school meetings where the club would sing songs, hear Bible lessons, and memorize scripture. The school district denied the Good News Club's request because the district prohibited use of district facilities by any individual or organization for religious purposes. The Good News Club, as with TST here, filed an action alleging the school district violated its First Amendment rights and sought a preliminary injunction to prevent the school from enforcing its religious exclusion policy against the club and thereby to permit the club's use of the school facilities. In analyzing the claim, the Supreme Court assumed the school district operated a limited public forum, but noted that even in a limited public forum, the district's power to restrict speech is not without limits itself, and any restrictions on speech in the forum must not discriminate against viewpoints. The Supreme Court held it was quite clear that the district engaged in viewpoint discrimination when it excluded the club from the after-school forum. The Good News Club, the court held, had sought to address a subject otherwise permitted by the district, which was the teaching of morals and character. However, because the club sought to address this subject from a religious viewpoint, the district prohibited the Good News Club's speech. The court held this prohibition of the Good News Club's speech based on their religious viewpoint as to an otherwise permissible subject matter of morals and character constitutes impermissible viewpoint discrimination in violation of the First Amendment. The court also rejected the school district's argument that permitting the school to use district facilities would cause students to misperceive the club's permission to use district meeting space as an endorsement of religion, holding this concern no greater than the danger that students would perceive a hostility towards the religious viewpoint if the club was excluded from the public forum. The facts here are strikingly similar. TST sought access to the district's public forum for its after-school club, the ASSC. Regardless of whether the district's public forum is designated or limited, the district is prohibited from engaging in viewpoint discrimination under the First Amendment, again citing to Child Evangelism Fellowship, holding even if school district's forum was limited or closed, the school district could still not engage in viewpoint discrimination. Control over a control over access to a non-public forum can be either subject matter or speaker identity, so long as those distinctions are drawn in reasonable light of the purported purpose served by the forum. Okay, are viewpoint neutral. Have to be viewpoint neutral. TST sought access to the district's forum to provide young people with an alternative to other religious clubs that meet on campus after school, and to express TST's viewpoint of the 7 satanic virtues and of Satan as a literary figure who represents a metaphorical construct of rejecting tyranny, championing the human mind and spirit, and seeking justice and egalitarianism for all. Accordingly, TST sought to present a constitutionally protected viewpoint on religion and philosophy. The Satanic Temple is a religious organization. The government may not regulate speech when the specific ideology, opinion, or perspective of the speaker is the rationale for the restriction. This one's Child Evangelism Fellowship of Minnesota. The record indicates the district engaged in viewpoint discrimination by rescinding approval of TST's application based on the controversial nature of TST's viewpoint and the negative community reaction thereto. To exclude a group simply because it is controversial or divisive is viewpoint discrimination. This action is unconstitutional, regardless of whether the district operated a designated or limited public forum. Even in the school setting, a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint is not enough to justify the suppression of speech. Citing to Good News Club, declining to employ a modified heckler's veto as the basis to bar a group speech in schools in a school district's limited public forum. Monroe, the First Amendment generally does not permit the so-called heckler's veto, allowing the public with the government's help to shout down unpopular ideas that stir anger. The district's conduct is not justified by the substantial disruption test, nor the district's recent modifications to Policy 707. First, the substantial disruption test, as articulated in Tinker, does not apply to the instant action. We went over this on my last video, but I'm going to read a little bit about Tinker here because it answers some questions. In Tinker v. Des Moines, the Supreme Court held conduct by the student in class, or out of it, which for any reason materially disrupts classwork or involves substantial disorder, is of course not immunized by the constitutional guarantee of freedom of speech. In Dariano, the Ninth Circuit held this substantial disruption test, articulated in Tinker, permits school officials to limit student speech that materially disrupts classwork or involves substantial disorder, even when the substantial disruption is caused by the reactions of onlookers and not the speakers themselves. However, this school-setting exception to the First Amendment's general prohibition against suppressing speech based on negative reactions from listeners, the heckler's veto, is designed to address only situations where student speech causes internal disruption and disorder. In this action, the speech at issue is that of an outside community organization during after-school hours, not of a student during school hours. The differences do not end there. Here, defendants identify the shooting threat made by an anonymous caller causing the district to cancel classes for a day as evidence of a substantial disruption. However, this disruption was external, not internal. The anonymous caller was not a student, nor a district parent, but rather an individual from North Carolina. Considering Tinker expressly trained the substantial disruption test on conduct by a student, and the Seventh Circuit's determination that the test considers the school district's responsibility toward the captive student audience, as well as the unwillingness of any other federal court to apply the substantial disruption test to non-student speech occurring after school hours based on the hostile reactions of an individual external to the school district, the court declines to hold the substantial disruption test applies here. Second, that the district subsequently modified Policy 707. They made the start time, instead of after school, it's now 6 p.m., and they clarified the advertising restriction. They changed Policy 707 in the wake of this litigation. That does not transform the district's decision to rescind approval, its previous approval, into constitutionally justified conduct. And that site is down here. The district's subsequent modifications to Policy 707 do not alter the outcome of the instant motion. The district approved TST to hold ASSC meetings on district property on March 8th, April 12th, May 10th. The district rescinded its approval before ASSC could hold any of these meetings. This action by the district, based on the available record, violates the First Amendment. TST is entitled to hold these previously approved meetings under the same terms upon which the parties agreed when the district approved the TST application on February 16th. Indeed, the entire purpose of a prohibitory preliminary injunction is to return the parties to their last peaceable, non-contested status, the status quo. In addition to the district's decision to rescind approval of TST's application, TST also challenges the district's refusal to distribute flyers and parent permission slips for the ASSC to students in the school. TST alleges that although the district had previously distributed permission slips and flyers from non-school organizations, including the Good News Club and Girls on the Run, it refused to do the same for the ASSC. As to this allegation, however, the district does meet its burden to justify the restriction. Uncontroverted testimony at oral argument and affidavit statements from the district superintendent advise that while the district had a previous practice of sending home flyers and permission slips with students for non-school sponsored organizations such as the Good News Club, this practice was discontinued by the district as to all non-school sponsored organizations prior to TST ever applying for the district facilities use. Accordingly, while TST demonstrates a reasonable probability of success on the merits as to the district's decision to rescind approval of their application, TST fails to demonstrate a probability of success on its claim that the district unconstitutionally refused to send permission slips home with students. The remaining preliminary injunction factors weigh in TST's favor. We can probably skip this. There's not going to be a harm to the school district by allowing them, and of course, allowing, the Constitution to be followed is in the public interest. And so the judge grants in part the motion for a temporary restraining order, denying only the permission slips being sent home. Wow. So yeah, that reveals a lot more than we knew a month or two ago from the initial news reports and things. It wasn't really based on the advertising restriction. The denial of the application for the after-school Satan Club was based on Jamie Vlasaty's, and I'm assuming the school board and other administration officials' desire to keep the after-school Satan Club out of Saucon Valley because they don't like the after-school Satan Club. Now, I understand that it is provocative, but the point is also to offer an alternative to religion. If you're wondering what in the world, who would create, the Satanic Temple and the After School Satan Club and all that, and do all this stuff as like a provocateur, well, think of the Protestants that left the Catholic religion. They weren't happy with the Catholic religion. I'm sure there's a lot more in this history than I'm going to go over now, and I'm sure I don't know all of it. But you do have the situation where someone's unhappy with their religion, so they create a new one. This happens over and over and over again throughout history, and that's really what's happening here. People who were upset or frustrated with their religion went and joined a different religion or started their own under the terms that were more acceptable to them. And that's what the Satanic Temple has done. So you can disagree with the Satanic Temple all you want. I will defend to the death your right to disagree. But what you're not allowed to do is treat entities or people differently based on their viewpoint or based on other prohibited discriminatory factors, protected classes. The Second Amendment is right up there too. It's in the United States, it's considered a right and can't be discriminated. Well, this applies to the First Amendment too, and it applies to the freedom of religion. The freedom of religion does not mean the freedom of one religion. It means the freedom of all religions, and to me it also includes the freedom from religion, if you don't want to be subjected to it. So I think Jamie Vlasaty is a coward because she couldn't stand up for what's right, what her job is as a government official. It's one thing for her to say, personally, I disagree with this, but I'm in the public position of superintendent, and I therefore need to do my job of executing my duties as a superintendent. Instead, she broke the law, violated the law on behalf of the school district, and now the school district is subject to not only this sort of humiliation and embarrassment, but I'm assuming there will be a motion for fees and costs coming at the end of this thing. Now, this court case is not over. This is the beginning of the court case, a preliminary injunction or temporary restraining order that exists for the duration of the case, and then the judge will make a permanent injunction, if the case warrants it, after finding in favor of the plaintiff at the end. Again, if the case warrants it. So there will be potentially litigation, discovery, a trial. There will be affidavits and depositions and all that. I'm guessing the school doesn't want that, because that will just run up a bigger and bigger bill, both for the school and for the ACLU, who will then bill the school through a fees and costs motion at the end. And the ACLU will get their fees and costs paid for, because that's how these civil rights claims work. So this is not the end of the case. This is certainly a good preliminary win, and it's a very good indicator of how the case will go later. But we have to wait for that. There might be a settlement. A good idea would be for Saucon Valley to settle with TST by paying the ACLU's fees. Plus, I don't know, what the typical going rate is for a civil rights violation, but I'm assuming that TST is more concerned with getting their club recognized on equal grounds than they are with getting money for a civil rights violation. Anyway, that's what I have for you today. Let me know what you think in the chat, in the comments below, and I'll take a few minutes here to play you out. Let's see here. Viewer activity. Where the super chats? The super chats don't go in here anymore? What are you doing, YouTube? The super chats don't show up in the dashboard anymore. What the heck? I gotta go scroll back on the stream. I saw a couple of them. Thank you to Rob Del Tony for your $10. If saying SVSD hosted ASSC means it sponsored ASSC, then YouTube hosting infringing videos means YouTube sponsored piracy. But this Christian knows copyright First Amendment doesn't work that way. Thank you, Rob. And I can't see back further than that. So I don't know why there's no... why your super chats aren't showing up here. Oh, yes, they are. Okay. I see it now. It finally showed up. Anyway, love you all. Thanks for joining me. Look forward to seeing you in the videos that drop. And that's it. Bye.